We're going to move forward now then with our next panel, which is going to be led by one of our research fellows, Amanda Bergold, and it's focused on an important topic which bears some relation to the last topic we talked about, forensics, but this time talking about eyewitness identification. So, Amanda, it's good to have you and your panelists.
Hi, my name is Amanda Bergold. Thank you. And I am a Quattrone Center Research Fellow. I am a psychologist who just graduated from John Jay College of Criminal Justice in New York, got my PhD in psychology. I've done some research on eyewitness identifications in the past, and specifically looking at the New Jersey versus Henderson jury instructions that were aimed to educate jurors about the quality of eyewitness evidence and help them evaluate it. So I will begin by introducing the topic, then I will introduce our moderators, and we will begin our discussion. So I think probably most people in this room would agree, hopefully we can find common ground on the idea that eyewitnesses are not always accurate. Exoneration statistics document this fact. The Innocence Project DNA exonerations document that 70% of wrongful convictions that are documented with DNA evidence have an eyewitness identification as a contributing cause. And that has led to a bulk of research on factors that influence the accuracy of eyewitness identifications, a lot of which was done by Gary Wells, who's sitting right to my right. And that research has divided eyewitness variables into two different categories, one being estimator variables, which allow us to estimate the accuracy of the identification. These may have to do with the witness's view of the crime, or have to do with factors such as stress that may interfere with memory. And then the other category is system variables. These are amenable to best practices and under control of the system. These include things such as blind lineup administration, or the administrator not knowing the identity of the suspect in the lineup as they administer it, so they cannot subtly and unconsciously give cues to the witness about the identity of the suspect. I won't give an exhaustive list of all of those variables now. I'm sure we'll talk about many of them throughout our discussion. But the development of this body of research has led to several working groups. I know one of the original working groups in 1999, convened by the National Institute of Justice, contained 3 members of this panel. So Gary, Paul, and Mark were on that, and all worked together to co-author an eyewitness guide for evidence. Some of the recommendations that came out of that were that police departments should develop policies and procedures, provide unbiased instructions, have only one suspect per lineup, use a minimum of 5 known innocent fillers to distract from the suspect, standardize the photographs of lineup members, record witness statements, and prepare lineup reports. Another sort of arm of reform has been in the legislative and judicial area, and Karen Newirth from the Innocence Project has been involved in a lot of those efforts, and she'll be speaking on them more. But of course, the New Jersey Supreme Court case in New Jersey versus Henderson in 2011, convened a special master to hear testimony from many experts in the eyewitness field and developed jury instructions to help educate jurors, of course. That's what part of my research has been on. And more recently, the National Academy of Sciences released a report in 2014, which reached a consensus on many of the eyewitness recommendations that had been established before, but it called into question some of them, most notably sequential versus simultaneous lineups, and that will be the National Academy of Sciences concluded that there was no evidence for a benefit of using the sequential or one at a time viewing of photos over the simultaneous administration. Some of the new recommendations in that report, I won't go through all of them, were videotaping the ID procedure and using scientific framework expert testimony in court to educate jurors. So during this panel, we're going to discuss some of the past reforms. I didn't mention all of them. I think they're too numerous to go through. Then we're going to go on to the future of eyewitness reform, address some of the current debates that are going on right now, and discuss where each panelist believes we should go in the future. So we're fortunate enough to have people that have been involved in all sorts of areas of the criminal justice system. I'll introduce my panelists right now. Gary Wells is a distinguished professor of psychology at Iowa State University. He is an internationally recognized scholar in scientific psychology. He's authored over 200 articles and chapters and 2 books, and most of his research has focused on the reliability of eyewitness identification, although he has done some recent work on the forensic sciences and the forensic confirmation bias. His research-based proposals, such as double-blind lineups, are being increasingly accepted as law enforcement practices, and like Mark and Paul, was one of the founding members of the panel that wrote the Justice Department training manual for law enforcement. And then we have Karen Newirth. Karen is the senior staff attorney in the Innocence Project's strategic litigation unit. She focuses on the Innocence Project's law reform efforts around eyewitness identifications and confessions. She is a graduate of New York University School of Law. She clerked for the Honorable Whitman Knapp in the Southern District of New York, after which she was a criminal defense lawyer in private practice. Karen also recently published a really interesting paper in the Journal for Applied Research in Memory and Cognition on the evolving judicial treatment of eyewitness identification evidence. And then Mark Larson is going to be our prosecutorial voice on this panel. He is the Chief Deputy of the Criminal Division of the King County Prosecutor's Office. He speaks on a wide variety of criminal justice issues and has a long-standing interest in eyewitness identification. Again, he was on the National Institute of Justice panel that helped author the Guide for Law Enforcement. And he also has co-authored a paper titled Eyewitness Identification, an update on what chiefs need to know in the police chief recently, and is also currently involved in an interdisciplinary group conducting field research on eyewitness reforms in Washington State. And last, we have Paul Carroll. He is a 31-year law enforcement veteran. He has over 22 years of detective division experience with the Chicago Police Department, investigating and supervising criminal investigations. He's also authored several publications on eyewitness evidence and crime scene protection and investigation. He now serves as a consultant to numerous police and sheriff's departments and coroner's office. And he was also a member of the planning committee establishing the National Institute of Justice's Guide for Law Enforcement.
Paul will go after you if you don't show them this.
Oh.
Paul's book.
So I'm going to start with our first question. I'll let everyone answer. The way this panel will work was we're going to begin with discussion, and then at the end I'll open it up for questions from the audience. but we're going to allow each person to talk and then respond to everyone's responses. So I'll start with you, Gary. In your opinion, what are the most eyewitness reforms that have been addressed and reformed in the past, so successfully reformed?
Well, I think that's pretty straightforward. We now have, in addition to individual writings that I put out in the 80s and the 90s, but starting in 1998, American Psychology Law Society issued a white paper. This was all the eyewitness researchers across the country and Canada on what we know, and generated a list of reforms that needed to be made. Later, and I'll tell you what they are here in a second, but later the National Institute of Justice, the panel that we worked on, made its set of recommendations based largely on that same paper. The International Association of Chiefs of Police have, and then more recently the National Academy of Sciences. And the list, the primary list, I think, can be described as 6 main recommendations. I mean, I think there should be more, but the 6 main ones that have been embraced in various ways start with the idea that there should only be one suspect in a lineup. Everyone else should be a filler, a known innocent filler. That's a very important recommendation. It has been violated for decades, but we've called it out now as a very important recommendation. Secondly, these fillers, whoever constitutes the fillers, have to be selected very carefully according to some sets of procedures and care that make sure that the suspect does not stand out in some kind of fashion. Third, the person who administers this procedure should be when I first introduced this, I called it a double-blind administrator. You can call it what you want, a neutral administrator, but someone who does not know which person is the suspect and which ones are fillers. Fourth, there needs to be an explicit pre-lineup admonition given to the witness saying that the person who committed this offense might not be in this identification procedure, and that the correct answer, in effect, may be none of the above. Fifth, if the eyewitness makes an identification, there needs to be a clear statement solicited from the witness about how confident or certain he or she is in that identification. That needs to be taken right then, at that moment, before there can be other kinds of things that come in and contaminate that. And we've demonstrated through research how easily it is that you can contaminate the witness's confidence. So it has to be done right then. And then sixth, the sixth of these 6 is videotaping the entire process. The American Psychology Law Society recommended 5 of these 6. At the time, it was not recommending videotaping, but that was 1998. It was expensive. We kind of bought into the idea that maybe that wasn't always practical. The National Institute of Justice recommended 4 of these 6. Everything but video, which still at that time, because this would have been 1999, was considered not that practical. And also the National Institute of Justice did not, in the guide, the Department of Justice guide that we put out, did not recommend blind at that time. I think that was a horrible mistake that we gave in to a subgroup who opposed that, but it's been corrected. The International Association of Chiefs of Police says it needs to be blind. There are now 20 states that by mandatory statutes of some form or another, or in the case of New Jersey, order of the Attorney General, have to do double blind. The National Academy of Sciences included all 6 of these, as well as all 6 of these, and that includes the videotape, as well as some other kinds of things, for example, not using multiple identification procedures with the same suspect and the same witness, which is, believe it or not, done surprisingly frequently. So I think the set is I think that those 6 recommendations are well justified. The research backs them up. There are lots of organizations that endorse them. There still are 30 states that have not. So that's kind of the perspective from the research end of this.
So as far as police practices go, I think Gary has captured all of the principal reforms that have been important in the past. I think we'll talk about going forward. And what I would add to not duplicate what Gary has said is that there are a number of reforms within the judicial system that are quite important. So we address the police practices on the front end, but then we also need to ensure that judicial gatekeeping of challenged identification evidence is robust, is consistent with the social science research, and then that fact finders, typically jurors, are given appropriate context to assist them in weighing this evidence. And what we've been working on to try to do these things is first, reforming the Manson balancing test for addressing challenged identification evidence. And that's a test that was set down in 1977 by the US Supreme Court and then adopted in one form or another by every state. Gary and others going back 30 years identified real intrinsic problems with this test. Most notably, the test sets up a 2-part balancing where a court will say first, okay, was the procedure unduly suggestive? If the answer to that question is yes, then we look at a number of reliability factors, after which a court can decide to admit the evidence or suppress it. And there are numerous problems, probably the greatest of which is that we have learned from the research that suggestion in the identification procedure contaminates witnesses' memories for both the event and for the identification procedure, so that those reliability factors are altered by the experience of having had suggestive procedures. So reforming the Manson test so that gatekeepers are actually doing a scientifically valid inquiry to determine should this evidence go to a jury or not is, and if it should go to a jury, should it go in whole or in part? Should it be accompanied by some protections? These are really the important reforms at the court level. Likewise important are helping jurors who we know often are unfamiliar with the research or worse, hold views that are counter to what the research findings show. So it's very important that jurors who are going to hear identification evidence, which is highly persuasive evidence, do so with some context about how to weigh that evidence and how to evaluate it. And that has typically been in the form of expert testimony and more robust, scientifically informed jury instructions. And then finally, I think it's important to address what witnesses are permitted to testify about and how they're permitted to testify. So recently we've been really trying to get courts to take a more critical look in light of all the scientific research at in-court identifications. For decades, jurists have acknowledged both the power of the in-court identification, but also the theater of it, that an in-court identification for many reasons really lacks much probative value and is substantially prejudicial. So courts in Massachusetts and Connecticut have recently taken steps to limit the ability of witnesses to make in-court identifications. So to add to Gary's list of police practice reforms, that's my short list of what I think are important reforms that can happen in courtrooms to enhance the reliability of this evidence that we know to be often very unreliable.
Good afternoon. So the question is, what are the most important kind of reforms? And listening to Gary Dr. Wells, even this afternoon, I'm reminded of the debt that we have for people who have been looking at this for a long time and doing a lot of very hard work that has informed our practice. As a prosecutor, my function is broader, though, than just thinking about that courtroom dramatic moment when somebody does or doesn't make an identification and how that's weighted by a jury. We are looking simultaneously at all the way back to the critical question, when and who do we charge? What other evidence exists in this case? How do we go forward? Is this a case where we're going to take the case forward or not? Those are decisions that prosecutors are making, reviewing cases, police work, investigations every single day that bears on the crucial issue of guilt and innocence and doesn't have the glare of a trial, which I think we know nationally is somewhere around 5% of the total number of the cases that are charged. As we look at those issues and we think about sort of the reforms and what are important reforms for us, we are looking at both how police did things. Did they use practices that would promote reliability with our witnesses? That's important. It's important to know whether those 6 things or 5 things or 4 things were employed as part of what would make a witness tend to be more reliable. But the reality, too, is that a witness with a really robust memory can be put through a crappy process and still have a pretty good recollection and be very accurate in making identification. Conversely, somebody can go through a perfect procedure that was run and conducted absolutely perfectly, and that doesn't ensure that somebody's going to be reliable and not otherwise make an honest mistake. So we have to bear that in mind, that these are important things to do, but they're not always prescriptive of who we can or can't believe or when we should or shouldn't charge. The other thing that's sort of important in all this as well that we have to take into account, and ultimately juries do as well, are the sort of environmental factors. Sometimes they're referred to as estimator variables, but what are the environmental factors that are part of that witness, their experience that night, distances, lighting, emotional responses? These are all part of how people can be more or less reliable when they make identifications in the field. We look at all of those things as we make the crucial decisions about who to charge, when to go forward, when to move into the trial realm. So those are all crucial. I'm going to go backwards, though, and say that I think if I think of the most important one, and it's really hard to say which is your favorite child, I guess, but I'm sort of flipping it around, and I'm going to say I believe, and I've been persuaded in the last couple of years, video evidence is crucial. And I analogize, now that I've watched more and more of the Washington State, the identifications where they're conducted on video, and I can watch everything that's occurring between the detective and my potential victim or witness. We refer to the black box earlier. There's no black box anymore. I don't have to rely on anyone else to describe what happened. What was the response? Sometimes those responses are very complex in terms of the human reactions and emotions. What gets said can be tremendously important. What gets said can be a lot of things all at once. And as I've watched more of them, I thought I would be tremendously challenged to write this down into some narrative that would fully capture what happened when one of those witnesses made a powerful identification at the end of this sort of a process or procedure. I liken it, 20 years ago, prosecutors were very reluctant to interview the witnesses, interviews of children who had been sexually abused. There were privacy interests and a variety of things, but through all of those investigations at that time, the black box was a huge problem. The suggestion that sort of horrible and bad things had happened in those interviews, that I know horrible, but that children had been led to certain answers or pushed or prodded in some fashion to say what Uncle Jimmy did to them or not. Well, those issues went away when we brought a video recorder in, which I agree with Gary is ubiquitous technology to us now. I think it's crucial. I think like those child interviews, we can take the black box away, and then it solves a variety of the other problems that are related to some of the other recommendations. When we have that record and a confidence statement is asked, which I think is number 2, we really know a lot more. We were preserving something that is forensically significant, and we can worry much less about what they learned 10 minutes later, an hour later, or on the eve of trial. We've got the evidence that both the prosecutor wants, but first the detectives want. The prosecutor absolutely wants it to really weigh. If this is a close case, if I don't have that kind of corroboration that I would like to have, am I going to file or am I not? I want to see the real thing. I think similarly, though, judges, juries, everybody wants to have that sort of evidence, and I think we can bring it to people reliably and regularly. So those are my two videos at the top. I think confidence statements, for a variety of reasons that I think we'll talk about later, are also very crucial as well. Paul?
Good afternoon. It's a pleasure to be here as always. I'd like to agree with Gary on most of what he's, matter of fact, on all of what he said. But I want to remind people here that when we went to the Justice Department and came up with these standards at the time, we were still using mug books in police departments. And they've been changing so fast. And the problem is the people that develop the programs for the police departments are developing it and then trying to meld it, the police departments are trying to meld it to what they need it for. Add into that governmental budgets are so tough to get through that when we put something in the budget, by the time we get the money for the budget and put out bids for it, we're 3 generations behind. Now, going back one step further, in jurisdictions that don't have laws requiring police to do certain things, there's no training for a detective or a patrol officer on how to do these procedures. And most of them are taught, from hand to mouth, from a more experienced detective to a younger detective. And the problem there is, what if the older guy's been doing it wrong all this time? So instructions that the researchers have come up with, probably some of the best things, instructions to the witnesses prior to them viewing, is really important. And again, I've given over 400 lectures on eyewitness evidence since the late 90s when we first put out the manual, and almost without a doubt, when you go into a room and ask the police officers how many of you have ever had any training on eyewitness evidence before, you're lucky if you get one person in the whole room. So that becomes a problem. And then when we get to court, I see defense attorneys are in there protecting the record in case of an appeal and don't know about the procedures. So where they could be the balancing act, they tend not to have the skill or interpretation of the police officer as to what they did, which is right or wrong. So I'm a big proponent in going in and forcing police departments to train their people and teaching them the value of evidence. Now, I was in here a little earlier when they were talking about the shoe print. Well, a shoe print's a great thing, or can be, but it has to be taken in the context of what it's worth. When I do any training for law enforcement, I train as a follow-up investigator, whereby you do the triangle form of investigation, which basically says you want 3 sides or 3 corners of the triangle taken care of, which is an identification, physical evidence, and a confession, and all 3 corroborate each other. Now, we don't often get to all 3 points, but if we can get to at least 2 and corroborate it, because an eyewitness identification, even in court, is probably the most theatrical or most important part of what a jury looks at. I'm from the era of Richard Speck, and some of you older people might remember that Richard Speck killed 8 student nurses in Chicago back in 1966. And when the 9th victim, who was still alive, came off the stand and walked up to Richard Speck and put her hand on his shoulder and says, "That's the man," there's no way they were going to cut him loose. It's probably the most important thing we do, and while it's an important piece, it needs to be judged for the value that it is in only one part of a criminal conviction and an investigation.
Does anyone have any responses to what anyone else said? No?
I guess I would add one, I tend to agree, I agree with Mark that recording is incredibly important, and I think that as we start to see ID cases where procedures have been recorded filtering up to appellate courts, I think we're going to see some interesting shifts in the courts. But what I would add to what Mark said is how important it is to have a blind or double-blind administrator, even if the procedure is recorded, because we know from research that people viewing videotapes often miss suggestion or confirming feedback that can occur when the administrator is blind. So agree that recording, and I think you said confidence statements are critical, but I would add, I think you need the whole package even when you have recording, because people view those recordings with their own biases, and we can't really count on them to see everything that may be there.
I want to second that, and you have to make a decision. Usually you're talking one camera, and usually that camera is focused on the witness. So the camera isn't focused on the detective's reactions, the detective's nodding, the detective's, raising eyebrows, the detective shaking head, the detective winking. Or just all those nonverbal behaviors. The idea that a jury is going to be great at finding those things too, but they aren't even a part of the video record. The video record is really to record what's the witness say. What you've got to do is you've got to use a neutral administrator, somebody who can't steer the witness, because they don't know. They don't know which one's a filler and which one's a suspect. This wasn't, when I came up with this, I didn't just pull this out of my ass. This is a staple idea in science, right? This is how science is done. It's done using double-blind procedures. You would reject manuscripts and scientifically submitted to the journals if they didn't use double-blind procedures. But we've sentenced people to life in prison and worse based on non-blind procedures, non-blind testing procedures. And it's really it's not difficult to do. New Jersey's been doing it since 2002, and other states are now doing it. It just really should be an absolute requirement.
Let me second that for Gary. In the jurisdiction where I'm from in Cook County, one of the busiest criminal courts in the country, I used to kid the public defenders, who were a lot of my friends, about be careful what you wish for, because when you get it, you'll have nowhere to go. Well, if I've got a recorded statement and I have a double-blind administrator to a lineup, they have no motions to file. They have nowhere to go. And when we instill this in the police departments, what a great idea it is, and how much money it saves in overtime, they just bounce off the walls. On the other hand, police departments, like any government agency, the response to anything new is, we've never done it that way. So we need to change that attitude. But Gary's right about the double blind. Anytime you do that, it just takes all the questioning out of it, and that the inadvertent. I used to think when I got a confession, or if I got a pic from a picture, that my mouth would go up like this, like the cat that swallowed the canary. Now, I looked at it in the mirror a couple times, and it didn't happen, but somehow if I feel it, it's possible that I would convey that to somebody. So I will go with the researchers on that one, and I'm sorry we didn't put it in at the time, but we wanted more research in the field. I didn't realize it was going to take us more than 20 years to get here at the time. Otherwise, we would have pushed for it harder. But I agree with the researchers 100% on that.
Okay, so I think we sort of addressed the avenues to eyewitness reform. So I'm going to go right into what are the greatest barriers that each of you have encountered in reforming eyewitness procedures? We'll start with Karen this time.
I thought I was going to have a minute to piggyback off somebody else's brilliant comment, but trying to achieve reform through litigation, as all of the lawyers in the room know, is very, very difficult, right? It's incredibly slow. As Paul points out, the less suggestive procedures that are happening in the world will lead to fewer suppression hearings or more correct admissions, which leads to fewer opportunities to litigate issues that we want to reform. Likewise, when you have defense lawyers who are doing a better job litigating this stuff, and prosecutors who are making more scientifically informed decisions, again, you have fewer opportunities to get to court and try to create reform. So I would just say, you know, from my perspective, trying to use the courts to create reform, just the general way that impact litigation works, and the fact that we're not using a civil litigation model is itself an obstacle. More broadly speaking, I think that throughout, whether it's talking about police, prosecutors, defense lawyers, or courts, the way that identification evidence has been used is so deeply ingrained in whichever culture you're talking about. Using in-court identifications as the example for kind of the judiciary, it's just the way things have always been done. I've found the kind of historical discussion about bail very fascinating, and there's a similar corollary on in-court identifications. In-court identifications go back to a time when courts were roving and people needed to be brought in and identified, and you didn't have an opportunity to do a out-of-court identification procedure. And we now have a legacy from, you know, a time before we could do all of the things that we do routinely now, and it's left us with a procedure that really adds nothing of evidentiary value, but it's what we do, it's what's always been done, it's what jurors expect, it's what, you know, so it's deeply ingrained. And the same, I think, is true, as Paul was just mentioning, for police, and the same can be true, you know, if you look at any other part of what to do. And I guess I would only add on the cultural point is, and I think there's this thread running through comments already, is that we need to shift the importance of eyewitness identification evidence within the investigatory framework and the importance within the prosecutorial decision-making. We know that this evidence is highly unreliable, that witnesses in all circumstances, whether they have great memories or poor memories, were subjected to good or bad procedures, do make errors quite frequently at rates that would keep a lot of other types of evidence out as a baseline. But we're not going to get rid of this evidence completely. It's never going away. So the question is, what's the appropriate role of this evidence from the start? And in my view, culturally, we need to shift it into a place of less importance, emphasize other aspects of investigation that create more reliable evidence, and then move forward from there.
You want me to go? We
Yeah, Mark.
going in order? Thanks. You know, I think now, today, and even in 1997, when that group began its work, now 20 years ago, I think my concerns have been the same, which is, I think there's, in a lot of topics, and probably it runs through a lot of what's been talked about here today, is a lack of appreciation for the parochial nature of our court systems and law enforcement. And I don't even mean that to be pejorative. It's not to say that they're parochial, like, you know, it's all Andy Mayberry, but that there are many, many departments. My county has 40 police departments that I do business with. My state would go, I can't even imagine going on from there. And so the idea that we're going to penetrate down to those levels and get real change and reform, or to have people be more knowledgeable and to be more fully trained. Because even if we get past just sort of some of these system variables and a few things, I think what we really want, and Karen, you touched on it as well, I think we want police that not only sort of know how to do an identification procedure fairly, but appreciate what the sensitivities, what the issues are, what's special about this type of evidence as they talk to those people, as they gather information from them, as they marshal them through the process. That's really crucial. And I think there's a lack of appreciation for that. And I think, you know, part of it is just the way our country is set up. We do not have a national law enforcement agency. So I think we need to think about that. But that was apparent to me then, that we were going to write a book. It got published in 1999. We had debate then, was there something else we could do other than to write a book, which people may not be waiting to read? And the answer was no. NIJ had published a bunch of books, and they were going to publish another book. And it wasn't a bad book, but how much change was there going to be through that book? They promised in the writings of it, well, we're going to do field tests and do validations, and we're going to take this forward out into the, well, they didn't. They published a book and they moved on to another topic. So I think that challenge is still in front of us, finding ways to really penetrate. That is what our efforts in Washington State have been centered on, is how do we actually move this down to the ground level so that we can walk away confident that there's actual change. And frankly, even in the states where they've legislated it, I think it's uneven. I think they've always found that they've got the sort of change they wanted. We changed the law, but that has some effect, and it's not a bad thing, but it did really move things forward. So I think we need to be much more thoughtful and more strategic about how we train and bring these issues down to the people doing the work. And that's prosecutors and cops.
Yeah, Mark's got 40 jurisdictions. In Cook County, Illinois, we had 122 jurisdictions in the county. So training was a big issue. The biggest problem was things are conducted in our criminal courts based upon the way we've always done it. I mean, that's history. This is what we do. I think we need to get to the judges. Some of the lectures I've been given is to some of the judicial classes. We got called into Boston one year, Ken Patnoe from Northampton, Massachusetts, and myself, and a judge asked us a question, what would we think of a defense attorney and a prosecutor who agree that their client will plead guilty if the victim can pick the guy out of the bullpen from among the people that have been arrested overnight? Well, that's great. What if they have the only white guy there? What if they have the only Hispanic guy there? But they were allowing that to happen just because it was expedient and we can get away with this. I testified in front of Judge Ito a couple of years ago in a murder case where when they audiotaped the ID procedure, which was from photo books, and the judge allowed it in even though the detective had made the pick, in my opinion, and told the victim who it was. And the judge left the evidence in because, after all, that's the state's only evidence. Well, I thought that was kind of silly, but, you know, that's kind of the way it goes. So, I mean, this is a big, big circle. Where do you start from? In some cases, it's the integrity of the detective running it, or the fact that police supervisors are so busy they don't have time to supervise detectives who are basically independent units. For those of you who saw BuzzFeed a couple of weeks ago, there's a detective named Guevara out of Chicago who worked in the unit I was in for a while, and I will personally give you an opinion, and at my age I guess I could say this, that in every unit, in every police department, there's one guy who you know he's lying every time his lips are moving or if he's at a keyboard. Mm-hmm. And this is the integrity of the people we hire. And a lot of them just go in there and it's lack of supervision because they want to get a conviction and they think they've got it right. One of the problems with eyewitness evidence is we put people in lineups, in photo spreads or live lineups based upon a hunch. You know, in smaller jurisdictions, we have the frequent flyers. So anytime something bad goes out, let's get his picture and show it to the victim. Well, sooner or later, he's going to get picked. I mean, there's no way around it. So there's a lot of room for change here. The best place, and I think Gary mentioned it, was New Jersey, where the Attorney General came down after the Supreme Court had told them, if you don't do it a better way, we're not going to let your eyewitness evidence in. The Attorney General, who had control of all the police departments, said, in 6 months you will do this or else. And you know what? They screamed, they hollered, and guess what? It worked. It's one of those things.
Okay, quickly. So the issue has to do with barriers. What are barriers to reform that we know about or have experienced? New Jersey is an interesting exception, and no one else can sort of replicate because only the state of New Jersey does the Attorney General have authority over all law enforcement. Basically, there are over 17,000 law enforcement agencies in the U.S., and they're all pretty much independent. When we developed this guide which we published in 1999 from the Department of Justice, sent it out to every law enforcement agency in the country, over 17,000. We know, in fact, by follow-up that most all of these got filed in the round file right away. Just boom, oh, something from the feds, boom, right? Because the federal government doesn't control law enforcement in this country. And in fact, the federal government does very little law enforcement, period. As you might know, almost all of it happens at the local level. But barriers are, you've got a status quo effect. Every system resists change. Police departments are no different, right? You've got the kind of, we all know about the not in my backyard effect. Well, most jurisdictions think, okay, yeah, this is a problem, like you talk to Chicago, oh yeah, this is a problem probably for Dallas, but we don't have a mistaken ID problem here. And then, Kansas City says, oh yeah, well, Chicago has a problem maybe, but we don't. I mean, everybody thinks everybody else has a problem. Yeah, go talk to them, but they think they themselves don't. Actually, what happens is you take something like Dallas, and they were never under the illusion that they didn't have a problem because they have so many DNA exonerations. But why do they have so many DNA exonerations? Is it because they're bad and Kansas City's not? No, it's because Dallas preserved the DNA and Kansas City didn't, right? So Dallas has all these problems with, they have more DNA exonerations and mistaken ID proven mistaken ID cases than any entire state. This is just the county, Dallas County, except New York. I think New York beats out Dallas County. The state of New York beats out the county of Dallas. But that's because Dallas was so good, for whatever reason, about preserving its DNA. So what happens is, my point is that one of the barriers is jurisdictions think it's not, they don't have a problem. But remember, these are problems that are hidden. If you don't have something as definitive as DNA, your chances of proving a mistaken ID are pretty small. Also, some of the resistance comes from people believing that, fearing that they're going to lose convictions of the guilty by doing things in a different way, or feeling that it could call into question, prosecutors sometimes feel like it could call into question their prior convictions, which were based on other different procedures. But also, one of the barriers is that you get these responses from jurisdictions that haven't bought into these reforms yet, saying, look, you know what, no court has ever suppressed any of our IDs. And they're right, because courts don't do that. They just don't.
Right.
It's almost impossible to get an ID suppressed. The witness has to almost pick somebody else first before they picked your client in order to be able to have an argument that maybe this witness isn't reliable enough to get in. So,
And often not even then.
not even then. So what happens is courts have a role to play here in putting pressure on jurisdictions. If they were to put pressure on jurisdictions, jurisdictions would fall into place quickly. That's what happened in New Jersey, but it didn't take us 6 months. It took us 18 months because 9/11 intervened and slowed everything down. It happened quickly in, for example, Oregon, when Oregon Supreme Court really got tough on these issues and threatened to start suppressing or using various mechanisms of their own. Then all of a sudden, these agencies, these law enforcement agencies are like, hey, let's get some reform. So all these things where I talked about what police ought to do, Karen talked about the courts, these come together. All these directions of pressure and influence are needed to knock down these barriers.
See, when I ask police officers at a class, how many of you ever had an ID suppressed? You never get a hand up. And then I ask, how many of you ever heard of one being suppressed? And every so often you get one up there. And then he'll say, but was the guy convicted anyway? And of course he was. The judge left enough in there to convict anyway. So you begin to wonder, I mean, where is the value of this evidence and why don't they see it as wrong? When I teach a class, either I change a tie from morning to afternoon, or I put on a different color shirt the next day and ask everybody in the room to write down what I was wearing. They stared at me for 8 hours yesterday. what color was my tie this morning, or what color was my shirt yesterday. If 2 out of 40 get it right, I'm surprised. I mean, that's how fragile this is. One of the things I learned from talking to judges, until they hear about human memory, they never understand the concept of how bad eyewitness evidence is. So, I mean, this is a whole systemic problem from basic police hiring all the way up through the police, the defense attorneys, the prosecutors, and the judges, and the appellate court judges. I mean, it's a systemic problem that we've tried to address with some issues with police departments. When we started this, I was a training coordinator for detectives in the Chicago Police Department. Now, there were 6 to 10, 1,000, depending upon what year there were. And I had trained them all at one time. And we were the only department in the country that I could find that had a lesson plan and taught eyewitness evidence. The only one. Of course, we also did live lineups, which I'm personally more in favor of, but that's a topic for another day. But it's just one of these problems that just lays there and nobody looks at until DNA came up. And it's, oh my God, are we really doing this? You know, and like Gary said, with the DNA problem, we get the overturned conviction. What's the number these days, Karen? What are you, 318, 320?
349.
349. When we started, it was in the 100s. These are mostly cases in the murder and sexual assault categories, which are the most serious crimes we deal with, but they are the smallest number of crimes in the system. We don't collect DNA at other cases. I don't know why not. I mean, we'll go after people, maybe for purse snatching, but how about we could swab a steering wheel in an auto theft and run it and get the DNA and get the right guy. But nobody wants to spend the money.
Does anyone have a response? I have a follow-up question. So I think a lot of the discussion has been based around the fact that eyewitness identifications are incredibly unreliable, and we kind of had this conversation during the last session. Is there any merit to the sense that maybe we shouldn't allow eyewitnesses to testify? That this evidence is so unreliable. We kind of had this conversation recently with the Quattrone Center Advisory Board. The question came up. I don't think there was a concrete answer to it, but should we just stop using it?
I don't think you can stop using it. I mean, when I've run lineups, it's amazing that when you get the right guy, the person comes up. Now, I was doing live lineups, and we pulled a curtain one day, and the guy the witness and I were like 14 feet away from the window, and he screams, "It's the guy in the middle with the black shirt." Or if you're doing a sequential lineup, and you put down the fourth photo, the guy screams, "That's the guy." So it has a place, and it's a very important topic. I mean, how many cases will we have in sexual assault convictions if the victim couldn't testify that was the guy? I mean, basically, it's a very important part, but the question is, or at least to me, I think we give it too much reliability. Again, there is nothing stronger in court than somebody at the stand pointing to the guy in the green tie next to the deputy sheriff or the defense attorney, even if it isn't the guy, and saying that's the guy that did it. Because after all, the jury thinks, well, he has no reason to lie. Well, of course he didn't lie. He's just mistaken sometimes. But I think we have to use it. I mean, like the shoe print from this morning. I mean, we're not going to use the shoe print? I mean, it's like Wayne Williams and all the fiber evidence at the Atlanta child killers. Maybe not one fiber works. When you start to put on 40 fibers from one place, the probabilities come down that it could be anybody but him. But I think it needs corroboration. I've always gone after, again, like I said, the triangle form of investigation and to go get it. If you want to look at the best book on this, In Cold Blood, about the Cutler murder case, talks about, and this is before Miranda, before most of the forensic stuff, how they kept going and going and going until there was no more evidence to get. And that's what we've got to train our law enforcement people to do. And the defense attorneys have to understand what the police departments are going to do. And I think the researchers, and Gary's heard me say this 100 times, should take a sabbatical of 6 months and come work in a detective unit in a major city and just watch how we do these things. That can't be replicated. And I'm in favor of the research. I mean, he turned me around 180 degrees with his human memory and this kind of stuff. But I remember one of the researchers one day called us, and he said, instead of doing a show up at night, a one-on-one, he says, why don't you take the guy's picture and then put it in a six-pack? I said, well, what if the guy doesn't want his picture taken? What if I don't have a camera? Well, take him to the police station. What do you mean? He doesn't have rights? I mean, I can't take his picture if he doesn't want me to take his picture. I mean, there's a lot of procedural things we have to deal with other than that we all need to understand where each of us is coming from to help the system get it right more often. Because as far as I'm concerned, there's no appeal right to I'm innocent. I mean, the appeal right is you violated my rights when you convicted me, barring DNA evidence. You can't say I didn't do it and go for another trial. The judge said you did it. The jury said you did it. And that's our biggest problem. We're fighting that.
So my take on Amanda's question about eliminating identification evidence, I would be totally opposed to that. It does put away a lot of bad guys, and it would give way too much consolation to perpetrators if they knew that an eyewitness could not give testimony against them. One example I give of this, though, is like this. So the answer is sometimes, under the right conditions, it is reliable. And I'll just give you one example that we could all agree on. I mean, suppose that somebody kidnaps a person and abducts this person and holds on to them for a week. And during that time, they're never masked. And this person who was abducted sees her abductor every day. Right? Would we not trust an identification from this witness if we, even using potentially bad procedures, like a show-up? Is this the guy who abducted you? The reliability of her memory over a period of a week, under multiple conditions during the day, seeing this person 7 days out of the week for hours at a time, of course that's reliable. Now, cases aren't usually that extreme, but as you move along this continuum from, a guy running down the street, and yeah, I saw that guy, right, to spending considerable amount of time with this person, there's a continuum. And at some point, they have a pretty good memory. And if you use the right procedures, you can test that memory, and you can employ various kinds of controls, like the fact that this person who is your suspect is embedded among fillers, good fillers who also, how was this witness able to pick that person out and be positive if it wasn't that person, right? So under the right conditions, we can trust this kind of evidence. It's always better to get corroboration. But that's not what has happened. What's happened in the legal system is that we've collected these, we haven't created the right testing conditions. It's been sloppy. It's been suggestive. We reinforce witnesses before they get to trial. We make confident witnesses out of witnesses who weren't really confident at the time. The analyses of the DNA exoneration cases involving mistaken ID show almost invariably that the witness was never positive at the time. They're only positive once they get to trial. And that's all that the jury sees. If the jury would have seen how uncertain they were when they made the ID, which could happen with videotape, they probably wouldn't have convicted. So I think we just have to do this right and not just prohibit it altogether.
Yeah, by the way, in those exoneration cases with the IDs, the actual perpetrator of the crime wasn't in any, I think it was in one of the procedures. So it's a target absent lineup, and somebody was picked and convicted.
Mark and Karen, do you have a response?
Well, I'm concerned, I guess, about some of the tone from my partners up here. if you're the proponent of reform ideas, I think it's easy to see the world as like, it's just horribly broken. If all you have is a hammer, everything looks like a nail. There are horror stories. People honestly get things wrong. I've been doing it for 30 years, and I also absolutely believe that under a lot of conditions, very good people can make positive identifications that can and should be relied upon, and that the police work that surrounds that is mostly very good. And so I guess I have a different view. I'm not quite so negative about the state of play. I think there are things we can and should do different. I've devoted a lot of time and energy to doing that in my own jurisdiction and state, but I don't think things are that bleak. And so, yes, we should continue to use eyewitnesses in our cases, in our trials.
Well, I don't mean to make it that bleak, believe me, because I think we had to have eyewitnesses too. There's no way to convict without.
Karen?
Yeah, I agree with the other folks on the panel that getting rid of eyewitness identification is not viable or desirable. I think that shifting dramatically, though, the way we consider and treat the evidence is, I think I've repeatedly said it, and also, recognizing the context of the current criminal justice system with the number of people who are arrested and the number of people who are prosecuted and the number of identification procedures and the overwhelming nature of what's happening leads to more errors. And so I think that what some of the more interesting new research is getting at is how we can identify both practices and particular witnesses and circumstances that are more likely to be reliable versus those that aren't, and offering courts, somebody made reference, or a couple of other folks on the panel made reference to judges never suppressing evidence. Well, the existing legal framework sets up this choice of, do you suppress or do you admit identification evidence? And courts understand that suppressing that evidence will often mean the end of the case. But there are a whole range of things that courts can do with this evidence, short of having witnesses or law enforcement witnesses come in and testify about identifications. The Larson decision out of the Oregon Supreme Court, which used an evidentiary framework to kind of reframe the identification inquiry, talked about witnesses who had very poor opportunity to view and where their testimony should be permitted to go. And so one example was a witness should be permitted to say, this is what I saw, right? A person who looked like this, and then the jury should be making the decision about what that description means vis-a-vis the defendant who's before them. So there are a whole range of ways that this evidence can be treated short of admitting the identification evidence. And I think, using the research that's there, using the experiences, what we know from the DNA exoneration cases, folks on the panel have mentioned corroboration a couple of times. And within the eyewitness identification, wrongful convictions established through DNA, 53% involved other types of evidentiary errors. That number is supported by research by Casson and others that shows that eyewitness mistakes tend to contaminate other evidence. So, comforting ourselves with, well, we shouldn't worry about an identification if there's corroborating evidence. There's a very good reason to think twice about that. Likewise, within our cases, we know of at least 33 that involve people who had prior familiarity with the person they were identifying. And that's, a range of levels of familiarity from, having lived in the same neighborhood, seen someone in a store on prior occasions, to knowing people by name, saying that they recognize their voice or their car, having close personal relationships. Now, obviously, I hope it goes without saying that most people who have good familiarity, who are well known to one another, tend not to make those kinds of mistakes. But when we're talking about kind of the universe of some familiarity, those people can be prone, that sort of weaker familiarity can lead people to make mistakes, have source confusion about where they knew people from. So there are lots of places where mistakes are made, and I think sensitizing the system to both the research and what we know from the wrongful conviction cases and coming up with more nuanced ways of treating this evidence is what's really critical.
Well, can I jump in here one more quick? Historically, prior to evidence, prior to forensic evidence, prior to DNA, our court systems were convicted basically on eyewitness identification and confessions. And that's what you see on TV all the time, minus, NCIS, where the girl could do anything, for heaven's sakes, in a forensic lab. But let's say I get a woman who's robbed and she can't identify the suspect, but I get the guy and he's got her wallet in his pocket and he confesses. Do I really need the ID? But there's still an importance on obtaining an ID because historically that's what we've always used. So that's what's impressed upon the frontline police officer and the detective. They're looking to get that because that's what's expected. But in the overall scheme of things, in a rape case, if I've got his DNA and he confesses, do I care if she can identify him or not? But yet we're pushed to get that. And I'd like to see that brought down just a little. It's a very, very important part of what we do. And on the flip side, to back up Mark a little bit, the percentage, when you look at the percentage of cases that are overturned with DNA that had a bad eyewitness, the numbers are horrible. But when you multiply them by the whole system of how many cases there are in a year, that how many convictions we get, the amount of false identifications is absolutely minuscule. Now, truthfully, one is too many, and we can help by doing better police procedures. We can help by informing the juries and the judges and the defense attorneys in how to go in after this and what value it is. And we can get that cut down a little bit. But in truth, and I think Gary's research has always bore out, no matter how you do an ID procedure, if you've got the right guy, it doesn't matter how you do it. It's in cases with the least amount of evidence that it's most important to use the proper procedures, so you're more than likely going to get the right guy from your eyewitness ID. Because when there's a stack of evidence in a confession and the evidence is piled this high, you don't need the ID. But when you don't have any evidence, the jury falls back on what's left, and if it's only an ID, that's what they're going to convict on.
I just have to register my disagreement with the notion that the known misidentifications, is minuscule compared to the number of cases. The known are the known, and the unknown is
Unknown.
a big unknown. So we really don't know, what we're dealing with. Just like in the last presentation, the pyramid, right? The bottom of all the cases where identifications are used, where DNA is unavailable, or there's no other way to determine whether an identification was accurate or inaccurate, is huge and unknown. But I think, and Gary, you'll give me the right exact number, but the lab and field studies suggest error rates in the range of 1/3. Is that?
Well, about 1/3. This is based now on samples of, we've got over 6,000 lineups that that have been analyzed and the published work on them from actual cases drawn from police departments and investigations. When a witness attempts an ID, 1 out of 3 times, it's actually slightly higher than that, on average across all these published studies, picks a known innocent filler. They do pick the suspect, a somewhat higher percentage than that, but we don't know how many of those suspect picks might be wrong. We do know whenever they pick a filler, they're wrong. So they're wrong 1/3 of the time in which they make an ID attempt. That's, by the way, something that prosecutors never see because those cases aren't brought forward. But police know about it. Even police, on the other hand, when those jurisdictions started having to keep track, because we were doing the studies of how often witnesses pick known innocent fillers from their lineups, even they were somewhat surprised, although they certainly knew it was happening at a pretty good pace. But actually, it's a very small fraction of cases that have DNA. And when you look at the DNA exoneration cases involving mistaken ID, almost every last one is a case of sexual assault. Maybe sexual assault plus robbery or sexual assault plus murder, because that's where the DNA is. But sexual assault cases of strangers are a very small fraction of eyewitness ID cases. Most eyewitness ID cases are robberies and other crimes. So the fact that these mistaken ID cases coming from DNA are in the hundreds where they are, where have been proven, when in fact most places like Chicago and Kansas City and the Des Moines and other places destroyed the DNA evidence as soon as they were convicted, or potential DNA evidence in those days. There wasn't DNA testing. Means that none of those could be tested. We're missing all of those. We're missing all of those that got lost, all of those that deteriorated, all of those that never collected that evidence in the first place. And we're missing every robbery case that has pretty much ever existed cannot be a DNA exoneration case. How excited is that robber going to have to be to leave behind the kind of evidence that's left in a DNA case, right? So this is a very small fraction that we're looking at. These DNA exoneration cases are a tip of a very large iceberg.
Okay, let's move on to the next question. I'm going to direct this at Mark and allow him to suggest what questions he thinks that eyewitness researchers should be addressing that they're currently not. So which questions are the most important for the future, suggestions that you might have for eyewitness researchers?
Well, it's hard because I don't know what they are or aren't addressing. You know, one of the difficulties as I look back over 20 years, and even as I look ahead, and I hope we still get some time to talk about the NAS report too, is finding ways to have the academy, as it were, speaking professionally with the practitioners, and in ways that are, you know, useful for both sides. But I think what comes to me right now, and the issue that we're wrestling with, is how to best ask the confidence question. So this is the point in the investigation where the person makes some pick, and as has been described, we all agree it's very important right then to have the person say, how sure are you? Because we don't want to know tomorrow, we don't want to know when you're at trial, we know that you can be inflated, your sense of confidence can be inflated over time. But what we're also learning, and I think we know with new power more than ever before, is in many ways that confidence statement right then is also a proxy for their accuracy. We don't want to know the guy pointed at number 4. I want to know, as a prosecutor, the person pointed at number 4 and said, I am completely sure, or I'm not really sure, but it kind of looks like 4. Those two things are enormously important if I charge or don't charge, how that case moves forward. So I really need to know that. But believe it or not, there's a tremendous amount of variation about how to ask that. Many people react to it. Well, don't ask percentages. That's a bad thing. I don't know why, but that's sort of a first reaction over 20 years. We don't want to ask them that. And what would it mean? What does 95 mean? Well, it's beyond reasonable. So I don't know. Is it just tell us in your own words? That's another sort of phrase that's sort of in usage right now as well. And then there's scales. We're all used to using different scales for a variety of things. I'm highly confident, I'm not confident. I think it would be very, very good to have compelling research about that. Crucially, to take that research into the field so that it can be generalized, so that we know how it works in our cases with real people and not simply in laboratory settings. So that would be a huge, and maybe going on now, I hope it is, and Gary, you'll tell me if it is, because I'm sure you know. But I think the next really exciting thing beyond that is the use of technology. And we've been talking about this for 20 years, but there are aspects of this that are procedural. And where those things are procedural, it seems to me that modern technology, both in terms of constructing and administering lineups, is stuff that we should be able to find great technological solutions for that take a lot of these issues out of play. So those are two things that are very exciting to me.
Well, I'd like to see the researchers publish in the magazines that police read. I mean, some of us were nuts on reading Psychology Today in the 70s and some of the other articles, but they don't get into the magazines that Gary publishes in that are peer-reviewed. And every so often a defense attorney will get it, and it comes up with this. Well, one of the other problems when the researchers talk to us, I mean, I've been with Gary at a lot of places, and they come up with this what are we using? Estimator variables and system variables. Policemen look at that and say, what are you talking about? So we go in there and say it's things you can control and things you can't control. I mean, it's not that a lot of policemen don't have master's degrees these days. It's almost the reason they have doctorates. But we don't talk at the PhD level. We're meat and potatoes people. You know, tube steaks and French fries. But it'd be really nice to see. I mean, it took me, I'm telling you, we sat down at Oak Brook, Illinois the first time out in the middle of nowhere. You couldn't even walk to a movie theater. And with this panel, and we're going all over the country talking about these things. And most of us were so against anything that would involve this. It took us 2 years, I think, to come around, and we didn't come around all the way then. We only came around about 100%. Now we're 180%, and we're pretty much with the researchers on almost everything. But that's because we take the time to sit down after the meetings, and believe me, there were days we were screaming at each other. But afterwards, we'd go down to the bar, and we'd sit there and we'd talk, and everybody was passionate from their own position. Well, and once you get down and talk, we could understand each other. I mean, it worked out, it's much easier. So when we go to train, we train and we talk their language, but we don't talk about estimator variables, you know, and we talk in simple language that people, normal people, can understand. And, it's difficult to publish a paper and not do that. But if you'd come down to Law Enforcement Technology or the American Police Beat magazine, so the police officers could see this research, at least some of them would kind of get the idea what's going on, and they'd have some sense of, instead of, some of the police would read the appeal briefs. Well, if the judges don't buy into the research, we don't have to do that. Why would I do that if I don't have to do it? It's the problem. So it'd be nice to see why we should be doing it this way, and I think that'd go a long way into integrating the research and the practical.
Thank you. Karen?
Well, I agree with, both of these comments. I think technology will present opportunities for us to get rid of some of the most pernicious problems. The street show up should be able to be eliminated through a handheld device where, a photograph of the person who's being detained can be put in a lineup with 5 similar photos from a database, so that you don't have that highly suggestive procedure. You have the possibility for a witness making a wrong answer. You can actually do a memory test there. We were talking at lunch about some of the research that you're doing, which I think is really fascinating, to try to figure out, there's been a debate in the research about what's the best way to pick the filler. Should it be matching to the witness's description or matching to the appearance of the suspect? How close do you want to get to how similar do you want the lineup members to look? At some point it becomes too difficult and the test becomes too difficult and you're not going to get correct answers when you should. And I think that there's a lot that can be done through technology that will give us a measure for how similar folks should actually be, and also how we can identify photographs of that level of similarity. So I think technology is really going to deal with some of these problems. Other areas for research, and I know we're going to talk about the NAS report, but I think the report generally did an excellent job at highlighting where the research needs to go. Practitioners, law enforcement, defense lawyers and prosecutors working together with researchers so that, real important questions in the day-to-day work are getting answered, looking at the interactions of these system and estimator variables, right? What about when you've got stress and a long retention interval and a weapon, what's happening to witness memory? Are those factors canceling one another out? Are they enhancing one another, and so on? I think I mentioned prior familiarity before. I'm aware of only one study which was conducted with people using old yearbooks from their high school. So they were people who had gone to high school together and then trying to figure out how likely they were to correctly identify someone that they'd seen before or not. But I think we need many more studies to understand the role of prior familiarity on people's memory. And then more research on what makes good jury instructions or how jurors can be effectively educated so that they'll do a better job evaluating this evidence.
Great, thank you. Just for time reasons, Gary, do you have any responses?
No, let's go on.
Okay, let's talk about the National Academy of Sciences report, since that's been brought up a couple times. So I'll start with you. What were your impressions of the report? What were the strengths and weaknesses? What were your biggest sort of takeaways from the report that the National Academy released?
Well, just first of all, a little context. The National Academy of Science set up a committee. It was not eyewitness researchers. They were scientists from various fields. As well as there was also at least one judge on that in that group. But they basically reviewed the literature and what's known, and the idea was to decide what is reliable, what kind of conclusions can we make about this literature that that the social scientists have generated. And basically, in the end, what they came down with was an endorsement of every last claim of the social scientists on this. They were agnostic on simultaneous sequential, which a lot of people make a big deal about, but so were the social scientists. I mentioned before, we didn't push. The simultaneous sequential was developed in 1985. We did not endorse it as late as, in 1998 in that white paper. We did not endorse it. We did not endorse it, and we were agnostic in the 1999 and so on. So what they did do was they went actually further than the social scientists were willing to go by saying, and there should be training for judges, and there should be training, for law enforcement. They should learn about how memory works, not just that you're learning a set of procedures, but how memory works. I mean, the legal system relies on memory all the time. I mean, almost everybody who takes the stand is saying something out of some memory, right? I mean, most criminal trials and civil trials are an attempt to reconstruct the past. That's what it is, right? Something that happened in the past and reconstruct it faithfully. And it relies on a lot of people's memories. And yet the legal system doesn't know anything about how memory works and how it doesn't work and so on and so forth. So the National Academy of Sciences, I think, gave a nice treatment to this whole question. National Academy of Sciences gave a real shot in the arm to the idea of videotaping. And in general, it was a very good thing, I think, for advancing the development of eyewitness reforms and the more complete picture. So, for example, the National Academy of Sciences endorsed the idea of expert testimony, which already is allowed in all but one state, I believe, now. But these things are all changes. These things are all new. I mean, there was a time in which almost no state would allow it, and it wasn't really that long ago, quite frankly. So now the National Academy of Sciences also, I gave the opening presentation to them. There were other eyewitness researchers they relied on, but they also heard from prosecutors, they heard from police, they heard from all kinds of groups, and in particular, they immersed themselves into the published literature. So I think it was all in all a good thing. I was worried a little bit that they didn't have, that here's a group of people looking at this who aren't experts in any sense on eyewitness evidence, but in the end, they did a good job.
Thank you. Karen?
Yeah, I largely feel similarly. There were some important recommendations for the legal system with respect to the Manson test. That the report criticized or said that reliance on precedent is not appropriate. Reliance on science here ought to be the guiding force. It also recommended that courts conduct reliability inquiries, outside of the due process context to ensure the reliability of the evidence. It was very strongly critical of the value of in-court identifications, and as Gary said, supportive of expert testimony and also jury instructions. I think one of the frustrations that I've had in my work is that the report was critical, kind of roundly critical of the meta-analyses in the field, despite then going on to rely on them. And it would have been helpful if the report were more specific about exactly what the failings in the meta-analyses are and what those failings mean for the reliability of the findings. That's been a difficult thing for folks to get their arms around, but I understand that there are researchers in Virginia who are going to kind of work on that and hopefully rerun the metas. And then, I'll stop with that, Mark.
Well, great. Well, for those of you who are interested in this, I just urge you to read it and not to have somebody else tell you what it says, because it's long and it's about 60, 70 pages. It's a little dense if you're not a scientist. I read it several years ago, and I read it on the plane coming out yesterday as well. And it's true. These were a group of, I had some very passing opportunities to go and observe a very decorated group of scientists and others that were asked to look at this field from the perspective of they weren't in it. They were not in the little submarine doing this work. They had some objectivity when they looked at the whole thing. And they made a variety of important recommendations, video being one of them, which I agree with. Unfortunately, that's not a scientific recommendation. There aren't studies that tell you to do that. It's just a good idea, and I agree with it. Blind. It's not a scientific study. It's a good idea, and they adopted that as well. Certainly, when it got to the sequential and the simultaneous, that's not an insignificant thing. People have been testifying that you must pass into law a sequential display of photographs for years. And this group comes along and says, well, not really. There's no basis to make that recommendation, one way or the other. I think when we get into other areas, the estimator variables, the things that are very important to my practice, the person, as you say, Gary, running down the street versus this, what were the conditions, trying to understand those. This is really a dynamic area. I can't even imagine what it takes to study that. But what the NAS told us is we're not as far along as we think we are. There is a lot to do. That isn't to say it's not incredibly important foundational work that's been done. That's true. But we're not as far as we think we are. We have more research to do, and we need to sort of put aside confirmation biases about what we want to sort of see to be true and find out what is true, how things interact, as Karen talked about. They talked about the basic research of memory and perception, and they summarized this in several places, saying, however, this strong scientific foundation remains insufficient for understanding the strengths and limitations of eyewitness identification procedures in the field. Many of the applied studies on key factors that directly affect eyewitness performance in the laboratory are not readily applicable to actual practice and policy. Applied research falls short because of its lack of reliability or standardized data from the field, a failure to include a range of practitioners in the establishment of research agendas, the use of disparate research methodologies, failure to use transparent and reproducible research procedures, and inadequate reporting of research data. A lot of great work's been done. There's more to do. That's what the NES told us.
I'm generally very favorable with it, although when we were first told about double-blind and sequential, a lot of us had a big fit in law enforcement. But from a practitioner's point of view, I was very happy with the sequential procedure because they don't get to choose, and compare. There's no comparison with that. So I found that to be a big plus. And the agencies I've talked to that went to sequential procedures have been very happy with it over simultaneous, over the old six-pack. I mean, one department in New Jersey called me and said, you worked with them up there. They said, what do we do with our old six-pack folders? They all had these vanilla folders made up to put the pictures in. What do we do with them? I said, I don't care what you do. Don't throw them in the garbage, for like, start a fire with them. But a lot of the researchers have backed off of this recently, but from a practical point of view, I found it much better to use the sequential procedure in my mind, and I've been doing it for years. I used to show single photos one at a time because we didn't do six-packs. So it's something I grew up with, but there's no choice for comparison when they do that, and I found that to be a good thing. Now, without going into the NAS minds, what they looked at, I don't know what they thought, but that's it. The other problem I had with this study, and a lot of the studies that come out, again, comes down to how about the audience, the practitioners? And I'm not so much talking about the lawyers. I want to talk about the police officers who don't get this and don't read it. It isn't put in training bulletins and doesn't go to police academies. So we can understand what they're talking about. It just doesn't come to that level. For some reason, I mean, the police have decided to do it, and we have to do this, but nobody tells us how or why. It's just one of those things that you kind of accept. So it doesn't hit the audience I think it should get unless you're really, really, really interested in the subject. Now, a lot of detectives are, but most of the work is done by the men and women in uniform as the first responders. And if they don't understand this, I think the whole system can have a problem. So I'm more in favor of it coming down to another level. But generally, I was very, very supportive of it. Let me add one more thing. For those who haven't read all the research.
I think we should probably give a little time for questions. I think we only have like 7 minutes left. So maybe we can continue this.
Let me one fast statement. I've got handout this I gave to all the police officers in the classes with research on it from about 15 years back. So if you're interested in reading it, they're here. Just take one. And you might find it interesting to read. I did, and those that we gave it to did also.
Thank you.
I'm up?
Yep.
Okay. Would the panel comment, please, on lines of questioning, facial recognition software, and artist rendering early in investigation for the purpose of developing a profile of the suspect? Are there guidelines for that? Is there tainting related to that? Does that work connect to lineups?
I'll let these guys try. I will tell you from my standpoint of 30 years, the sketches, that I consider that the Hail Mary in an investigation when those sort of go out publicly, and we really, really try hard not to do that. I look at the exoneration cases and see that that's played into a number of them in really powerful ways. So I think there's probably, I shouldn't say more. I'm very, very concerned about the use of those sketches as a way to sort of go from, I don't know who did it, to all of a sudden you have 10,000 people who may look like a sketch.
I agree with it from a police point of view. They're usually standard composite number 202 with and without glasses. On the other hand, I did have a sex case where we had a composite done, and we're downtown showing this, and the suspect came up and looked at it and said, boy, that looks just like me. So it can work, but they are the Hail Mary. They're good PR.
I didn't hear the first in the list. You said something facial recognition and composites?
The line of questioning and facial composites and artist,
And by line of questioning, you mean,
what kinds of questions? Is there standards for what kind of questions we ask a complainant about the suspect, the potential suspect?
Well, yeah, others can say better, but, there's some great stuff out there about how police should, not just in eyewitness cases, but when you're trying to gather information from people out of their memory, which is what they do every day with witnesses of one sort or another, there's important, one sort of iteration of that is called the cognitive interview. But there are ways to interview people where you can sort of glean information that is going to be, that you're going to get more of it, and it's more likely to be more accurate. And I think it's sort of underappreciated in this field, in my estimation. I am trying to get my police academy to teach it. I will say, and no offense, but a police officer will line up 50 deep to go to an interrogation seminar. Getting them to go to a cognitive interview where they get to sort of talk to people more effectively, it's a harder sell. So we're trying to promote that in Washington.
I just support the same thing. The cognitive interview is the greatest because how you interview determines what you get. Policemen, especially the preliminary investigator, is taught to take the information the way it is in the boxes. So you get male, white, 16 to 18, 5, 10. The memory doesn't work that way. We want it to come out the way they want it to. And most policemen are taught to write reports like a newspaper reporter, who, what, where, when, why, and how. Doesn't work. So we need the more in-depth how to interview. It's been out there since the mid-'80s, and yet we're not using it.
Thank you.
Well, and the National Institute of Justice Guide on Eyewitness Evidence, on the collection and preservation of eyewitness evidence that we've been talking about, and that we were all on, has an entire section on the cognitive interview and how witnesses should be questioned that's quite independent of the eyewitness identification part. So that's in there. As for composites, or what we typically refer to as composites, most of these, I mean, there are still sketch artists, but there also are a lot of, police departments where, they bought the Faces program for $75 and they're putting together mouths and noses and eyes and lips and things like that. We've done a lot of research on that. There's a lot of research on that. These are bad procedures. They tend to muck up the memory of a witness instead of help it. The end product isn't very good. And they actually have, as a function of having gone through this kind of attempt to generate a face out of memory, the product that you get tends to change the memory so that they're actually less able now to pick out the culprit if they see him because you've mucked with their memory.
That's covered in the Justice Department books, and they're on the handout list.
Altogether, for the most part.
Thank you.
Thank you. Denise?
Hi. My background is actually as an occupational therapist. So when we would see some of our clients, before we would give them any psychometric testing or perceptual testing, we'd always give them a visual acuity test. And because this is eyewitness best practices, I was wondering if you start with that, if you take a look at visual acuity, especially if an eyewitness is witnessing a person from a certain distance away. And the reason I ask this is because there was a case in California recently where it was post-conviction and it was found that the eyewitness that was used was actually legally blind if you did the visual test. So someone along the line didn't ask that question.
I'm having like flashbacks of my cousin Vinny, but we all remember that as well.
But it's a very easy test to do. The DMV does it all the time. I was just wondering if that might be, in terms of discussion of best practices, a
I will
place.
say, I'm not familiar with the practice. I think it'd be an interesting thing to try in the field, and how it would apply to our, I don't know, but it's certainly relevant.
It's the
I don't know
eye.
that
It's
it's
the
done.
eye of the eyewitness. So it's just, it'd be interesting.
I would see, I think it'd be nice for a detective to have that when he does a follow-up, to know what we're dealing with.
And then the other comment that I have is when we would do these sorts of tests for our particular clients, we would have to be certified in giving those tests. So we would go through it just like you get certified for CPR. You go down to the Red Cross, you do a little bit of book work, you do a little performance work, you get evaluated, and you get your certificate in being proficient in that particular area, and you update it every year. And I was wondering if that kind of certificate process might be a partial solution at the police end of things to make sure they're proficient in being certified in using the best practices.
Well, when I was down in Georgia some years ago when they were deciding to put a law in, we got them to make a law that police departments must have written procedures that anybody who conducts a lineup or an identification procedure must have been trained in it and have it basically. Now, it's tough to get that through everybody, but it was one of the ideas we all put forth as practitioners. At least we'd know that they were trained.
And then the second part of that would be that they're proficient in it and they actually perform and do what they are taught.
Well, we would assume that they do that and they
Right.
teach them at the school and somebody at the department would watch them once in a while.
Thank you.
Thank you. John?
We've come across some cases where there are multiple interviews of the same eyewitness, and I'm interested in your thoughts on how to balance this, because on the one hand, we know that multiple interviews can lead to confirmation bias in the mind of the witness. On the other hand, it seems reasonable that in an unfolding investigation, you might not always know the questions that you want to ask in a single interview. So how do you balance the occasional need or the investigational need for multiple interviews with the risk that those interviews are actually corrupting your investigation as you go?
And is this like after an identification's been made? I presume that your concern sort of follows some identification's been made and now we're...
Well, or there are
I don't
situations
think
that
it's
we've seen in cases we've looked at where the witness can't initially make an identification, and then after multiple interviews, all of a sudden the ability to make an individual eyewitness identification is there. So the first interview they can't identify a particular suspect, third interview all of a sudden they can.
Just what they're saying, or they couldn't identify in a lineup. I've had a lot of people tell me they couldn't identify. And then the minute you bring them in for a lineup, they can identify. A lot of them are afraid to get involved with this. In sexual assault cases, I try to keep these, especially with children, I want to keep the interviews down. And most of us do a forensic interview now with a social worker and a psychologist, and people that know how to handle the children and get the right information. You want to keep those down. Sometimes we go back twice. Usually there's a preliminary investigation with a patrol officer and a follow-up with a detective. But again, if somebody tells me that they can't identify, I don't believe them. Because invariably they can, not everybody, but a lot of them can, but they'll tell you they can't. And my big concern was, at least from a prosecution standpoint, once you tell somebody you can't ID, you put in a report, the next thing I get is a defense attacking that. Well, you said you couldn't ID, how come you did? I mean, psychologically, I don't know if there's a difference here, but I mean, I don't think we're implying or putting anything into his mind. I mean, one of the techniques I use for the interview, like the cognitive interview, we have them do things backwards. From the time the first officer got here back to the 5 minutes before the crime, what happened, it's amazing what they remember. So if they're questioned right, you'll get some more information. The problem is teaching the officers how to get it, or the prosecutor. I mean, they're going to interview the guy before he goes to court also. We're kind of stuck with multiple interviews.
But I don't know if we're stuck with them, but I think I think you're highlighting a problem, multiple interviews, but also multiple procedures, which it seemed like you were implying.
It's certainly possible. I wasn't limiting my question to one or the other.
Okay, so, I mean, I think we can say multiple procedures over here, that's, a very serious problem, and
Same suspect.
yes, involving the same suspect,
Yes.
thank you, should be avoided, right. In the kind of other set of cases where you're talking about an investigation that's developing and there's some need to go back to witnesses, I think that recording can be very helpful, and I would analogize to the confession context, right? Brandon Garrett's research teaches that, 90-odd% of the false confessions in DNA cases were contaminated, and video recording can help us know when was information given and when, you can kind of timeline out how a memory changes. So I think recording of witness interviews could be very helpful in cases where it's necessary to continue to go back and to sort of see what's happening to the witness's memory over time.
I think you've highlighted just something that occurs to me that's more of a global thought that I'll promise is my last thing I'll say. But I think too oftentimes we want to look at solving this problem with, some sort of a cookbook. If we do this and this and this, everything's good. And the truth is these are very dynamic and oftentimes serious and hard investigations, and there's a lot of confounds. Things that happen with the way the person looks, the way they present, our ability to solve the case or not, and the steps that are taken. And more than a cookbook, I think we really need to have law enforcement and prosecutors, and in collaboration where possible, we need to know what are the principles involved? What are we trying to keep safe? What are the risks if we do this? How do we think through this strategically with this idea that memory's fragile and it's malleable? I think we want cops to know those principles as much as we need to have them have a cookbook. And I think that's what got lost a little bit in 1999, and I think it's still an issue for us today. More than just passing a law, we need to know how this works, because a lot of this stuff is very significant, a lot's at stake, and it's dynamic.
Thank you. And please join me in thanking our panel.